Hello participants, I welcome you to the 2-day certificate course on juvenile justice system in India. The topic for my discussion is the shift from the juvenile justice system to the criminal justice system. Herein we'll explore about the principles that have been borrowed by the juvenile justice system from the criminal justice system, and we'll try to find out how far and to what extent this is justified. You all know that under the present law, that is the JJ Act 2015, a new provision has been enacted, Section 15, read with Section 18 of the JJ Act. This provision has been in controversy since its enactment. This allows the adult trial of a juvenile who has committed a heinous offense and whose age is between 16 to 18 years. That is, a child between 16 to 18 years of age who is accused of committing a heinous offense may be sent to the children's court for adult trial. JJ Act defines heinous offense as an offense for which minimum mandatory punishment prescribed in any penal law is 7 years. So, under the present juvenile justice system, we have seen that it has opened up the gate for the adult trial of 16 to 18 years old child who is accused of committing heinous offense. This makes the study of JJ system incomplete without the understanding of the core principles of criminal law. We see that nearly 4.5 years have passed since the new juvenile law came into effect. Since then, a child alleged of committing heinous offense is continuously in a state of tension as between the juvenile justice system and the adult criminal justice system. Besides, the juvenile justice system is also struggling to preserve its own inherent character of child-friendly processes focused on the best interest of child principle and the uncertain future effects of the selective transfer of the child to the adult criminal justice system. This tension becomes more centered in the absence of concrete evidence to suggest that the selective transfer of children to adult criminal justice system would produce fruitful results. Before sailing through the intricacies of the newly amended juvenile justice system, let us understand the cardinal principles of criminal law and the need and the effects of borrowing such principles in the juvenile justice system. In trying to understand the influence of criminal law on juvenile justice system, we need to understand the aims of both the systems. It is rightly said that there is hardly any penal system which has a single basic principle to perform. Similarly, IPC, the penal code, prohibits certain acts and punishes the violators by prescribing a procedure which is just, fair, and reasonable. I'm talking about the entire criminal justice system. It has a procedure for punishing the violators, which should be just, fair, and reasonable. The aim is also to deter the other potential criminals and enhance the sense of security through the society. For certain nature of offences, the purpose may be to rehabilitate the offenders. The entire process works on the principle of natural justice and fair trial, which I believe is best ensured by the principle of presumption of innocence of the accused till proven guilty and the burden of proof on the prosecution side. Similarly, if we talk about the juvenile justice system, it also has numerous purposes to perform. The juvenile justice system, or the JJ Act 2015, makes an attempt to list them in Section 3 of the Act. Now let us try to understand the effects of the meeting of the purposes of juvenile law and the criminal law. A crime We know that it consists of two elements, mens rea and actus reus. Mens rea means the guilty mind, that is, the offense must be committed knowingly or intentionally, while actus reus means the guilty act, that is, there should be a desired outcome of the act. To hold a person criminally liable, the actus reus and mens rea must coincide. That is, a person cannot be held liable, criminally liable, for an act which he did not intend or which is committed accidentally. Now, if we try to look into the purposes or the principles which are incorporated in Section 3 of the JJ Act, we'll find out that presumption of innocence is the first principle that is mentioned in the Act. It provides that all children shall be presumed to be innocent of any malefied or criminal intent. It provides that all children shall be presumed to be innocent of any malefied or criminal intent up to the age of 18 years. This principle is based on the irrebuttable presumption of shall presume contained in the Evidence Act, which says that all children, irrespective of any exception, irrespective of any condition, shall be presumed innocent up to the age of 18 years. Thus, a child shall be presumed innocent in all circumstances. However, if we compare this with the Indian Penal Code, we'll find that Section 82 and Section 83 are relevant. Section 82 provides that children below 7 years of age cannot be held liable for an offense. While Section 83 provides that children between 7 to 12 years of age may be held liable if it is established that they have developed sufficient maturity of understanding the nature and consequence of the act. Thus, children below the age of 7 years are presumed incapable of forming malefied or bad intention, while children above 7 years of age but below 12 years of age are presumed to be so capable but may prove their innocence on individual basis. Thus, we see that the Juvenile Justice Act 2015 gives greater protection to children by declaring that children till 18 years of age are presumed innocent of any malefied or bad intention. It may be noted that the principle of presumption of innocence contained in JJ Act is contrary to the presumption contained under Section 83 of Indian Penal Code, which presumes that a child between 7 to 12 years are mentally mature, while the burden is on the child to disprove it. Whereas under the JJ Act, a contrary presumption is raised till the age of 18 years, which may be rebutted in certain cases. The JJ Model Rules 2007, if we compare this to the earlier JJ Model Rules of 2007, we'll see that those model rules also made a similar provision providing that a child shall be presumed innocent till the age of 18 years. Age of innocence was defined as the age below which a child cannot be subjected to criminal justice system. The JJ Rules 2007 made a salutary provision guaranteeing to children all procedural safeguards available for adults under the Constitution or any other statute, which strengthens the child's right to presumption of innocence. However, the same has been removed under the new law. JJ Model Rules 2007 also provided that child's presumption of innocence shall be respected throughout the process starting from initial contact to aftercare, which also does not find a specific mention in the JJ Act 2015, though it may be derived from the intent of the legislation. JJ Model Rules mentions the principle in different tone. Rule 10, Sub-Rule 7 of the JJ Model Rules 2016 provides that during interrogation, inquiry shall not be conducted in a strict sense of the adversarial proceedings. Powers conferred under Section 165 of the Evidence Act, which gives huge power to the court to ask any question to the parties in order to ensure that the due process is complied. It says that the powers conferred in Section 165 shall be used to draw presumptions in favor of the child. Further, Rule 10A, Sub-Rule 3 provides that during preliminary assessment, a child shall be presumed innocent until proved otherwise. However, the new provision under Section 15 of the JJ Act, which provides for transfer of children between 16 to 18 years of age accused of committing heinous offence to the adult criminal justice system, appears to be an exception to the general rule of presumption of innocence under the JJ Act. If we look at the second principle, it talks about the principle of dignity and worth. All human beings shall be treated with equal dignity and rights. Thus, all children shall be treated with equal dignity and rights shall be protected, though should not be discriminated or ill-treated. If we look at the third principle, it is again a very important principle. It talks about the principle of participation. It says it is based on Rule 12 of the UNCRC, that is the United Nations Convention on the Rights of the Child, which obliges the state parties to assure that children who are capable of forming their own views should have the right to express them freely before the court in all matters affecting them. Thus, all children shall be provided an opportunity to be heard in any judicial and administrative proceeding affecting the child. If we look at Section 8, Subsection 3, Clause A of the JJ Act 2015, it provides that the board shall ensure the informed participation of the child in the entire process. Also, Section 14, Subsection 5, Clause 3 of the JJ Act 2015 provides that in order to ensure fair trial, the board shall provide to every child an opportunity of being heard and participate in the inquiry. Further, under Section 102, the High Court, while hearing a revision application under the Act, cannot pass an order which is prejudicial to the child's interest without giving a reasonable opportunity of hearing. If we look at the JJ Model Rules of 2016, Rule 19, Sub-Rule 5 provides that the principles of natural justice shall be followed while ensuring the informed participation of the child and giving him an opportunity of hearing. Similar rules were found in the JJ Model Rules 2007, ensuring right to participation and hearing to the children. Criminal justice system also ensures informed participation of the accused at every step. Section 313 of CRPC provides that the court shall examine the accused mandatorily. Also, Section 165 of the Evidence Act empowers the court to ask any question, relevant or irrelevant, to the accused in order to ensure due compliance of the protection provided to the accused under the Constitution and other statutes. Moving on to the next principle, again a very important principle which binds all the provisions of the statute, that is the principle of best interest. It provides that all the decisions regarding children shall be based on the prime consideration that they are in the best interest of child and help the child to develop full potential. Section 2, subsection 9 of the JJ Act defines best interest of child as the basis of any decision taken regarding the children. The principle is borrowed from Article 3 of the United Nations Convention on the Rights of the Child, which provides that in all actions concerning children, the best interest of the child shall be the prime consideration. Besides, the term best interest of the child has also been used extensively throughout the JJ Act. However, it may be noted that Section 15 read with Section 18 of the JJ Act, which allows the child to be transferred to the Children's Court for adult trial, appears to be contrary to the best interest of the child principle, as adult trial is based on the principle of retributive justice. The next important principle is the principle of family responsibility. It says the primary responsibility of the care and protection of children is on the family, and children should grow in family environment for the harmonious development of their personality. This is also based on the United Nations Convention on the Rights of the Child, that is UNCRC. However, it appears that when a child is tried in a criminal court and is kept away from the family, this principle would be compromised. The next important principle is the principle of safety. All measures, it says that all measures shall be taken to ensure that the child is safe and is not subjected to any harm, abuse, or maltreatment which is while in contact with the care and protection system and thereafter. However, the proviso to Section 18, subsection 1, clause G, permits sending of any child, irrespective of their age or offense, to a place of safety. This is in clear violation of the principle of safety, which is aimed at provision of all measure to ensure safety of the child so that he is not subjected to any harm, abuse, or maltreatment while in contact with the care and protection system. We all know that place of safety is meant primarily to keep children from the age of 16 years, having committed a heinous offense till the age of 21 years, and sending young children there will be adverse to their well-being and safety. The next principle is the principle of positive measures. It mandates that all resources are to be mobilized, including those of family and community, for promoting the well-being of the children. Thus again, there is an obligation on the state to take positive measures for the well-being of the child. On the contrary, when we allow the adult trial of children, this principle is compromised. Moving on to the next principle, principle of non-stigmatizing semantics. Under the JJ Act, adversarial or accusatorial words should not be used in the processes pertaining to child. Stigmatizing a child would be fatal to their rehabilitation and reintegration to the society. Thus, efforts have been made to employ neutral terms while addressing the child. The JJ Act 2000, it is important to note that the JJ Act 2000 used two terms, juvenile and child. Under the old law, juvenile was used for children in conflict with law and child for children in need of care and protection. As a result of which, what happened was a negative connotation was attached to the term juvenile, which is why under the new law The term juvenile has been replaced by the neutral term child. Also, the JJ Act 2015 has encouraged the usage of non stigmatizing words. It discourages the using of terms like punishment, imprisonment, convicted, accused, etc. However, it is submitted where a child is tried as an adult, it would make less difference by what name he is referred to. If we move on to next principle, it talks about the principle of non-waiver of rights. It says that no waiver of rights of the child is permissible under the JJ Act. That means a child cannot be allowed to waive any of his rights under the Act. Thus, for example, when even where a child confesses his guilt, the board shall observe the principles of natural justice while disposing of the inquiry under the Act. A similar provision was contained in Rule 3, Sub-Rule 9 of the JJ Rules 2007. This is a special protection available only to children under the JJ system. This rule, this presumption, this principle is not available for adults under the criminal justice system. The next important principle is the principle of equality and non-discrimination. It says that all people, all children should not be discriminated, or rather, no child should be discriminated on grounds of sex, caste, ethnicity, place of birth, disability, and equality of access. However, considering the trial of child as an adult, it may be argued that the transfer of a child for trial as an adult is violative of the protection against inequality. The next important principle is the principle of right to privacy and confidentiality. Every child shall have a right to privacy and protection of confidentiality. Section 74 of the JJ Act provides that the disclosing of the details which has the potential to reveal the identity is an offense. Besides, Section 228A of the Indian Penal Code is also relevant for us. Similar provision was also made in Rule 3, Sub-Rule 11 of the JJ Rules 2007. UNCRC also provides for similar protection under Article 40, Subclause 2, Sub-Rule 7. This protection is special to the children under the JJ system. The next very important principle is the principle of institutionalization as the measure of last resort. It provides that a child shall be placed in individual care as the measure of last resort after making reasonable inquiry. United Nations Minimum Standard Rules for the Administration of Juvenile Justice 1985, also known as the Beijing Rules, also incorporates the same principle. The commentary to Rule 19 of the Beijing Rules justifies the principle by highlighting the negative influences on the children in institutional care, like loss of liberty, separation from social environment, are more severe on children than adults because of their tender age and early stage of development. Rule 19 restricts institutionalization in quantity and in time and reflects the Resolution 4 of 6th United Nations Congress, which says that a juvenile should not be incarcerated unless there is no other appropriate response. However, if a juvenile is institutionalized, then the loss of liberty should be minimized to least possible duration. Article 37, Clause B of UNCRC also provides that the arrest, detention, or imprisonment of child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate duration of time. Rule 3, Sub-Rule 12 of the JJ Model Rules 2007 also prescribed the same principle with a specific mention that it should be for a minimum possible duration. However, it is important to note that the JJ Act 2015 removed the mention of minimum period of duration, which shows the otherwise intent of the legislature. The next important principle is the principle of repatriation and restoration. The child shall be reunited to the family at the earliest and restored to the same socio-economic and cultural status as he was before coming under the purview of JJ Act, unless restoration is not in his best interest. This principle is based on the preamble of UNCRC, which recognizes that children should grow in family environment and in an atmosphere of happiness, love, and understanding for the full and harmonious development of personality. However, the mention of restoration to the same socioeconomic and cultural status should be understood carefully in consonance with the terms unless such restoration is not in the best interest of child, as many a times children fall in the purview of JJ system because of their poor socio and economic condition. This shows the rehabilitative approach of the JJ system. Another very important principle, which is special to children and the JJ system, is the principle of fresh start. It says that all past records of children shall be erased except in special circumstances. However, this principle does not apply to heinous offense committed by children from 16 to 18 years of age. Section 24 of the JJ Act provides for the removal of disqualification on finding of an offense, whereas it makes an exception for children found committing heinous offense. That is, the protection under this principle should extend to only children who are not accused or who are not found guilty of committing heinous offense. The next principle talks about the principle of diversion. It says the measures for dealing with children in conflict with law without resorting to judicial proceedings shall be promoted, unless it is in the best interest of the child or the society as a whole. The principle promotes the transfer of children from the judicial proceedings, that is, children should be diverted before the judicial proceedings begin, so as to protect them from the stigma attached to conviction and sentence. Thus, measures for dealing with children in conflict with law without resorting to judicial proceedings shall be promoted unless it is in the best interest of child or society as a whole. The principle provides for diversion of children from judicial proceedings. Under the JJ Act, the judicial proceedings are performed by the Juvenile Justice Board, Child Welfare Committee, and the Children's Court. Thus, the principle directs that efforts should be made to divert the child from all these institutions. A reference to Rule 11 of the Beijing Rules shows that the efforts should be made to divert the children to community-based programs. This principle is also special to the juvenile justice system as opposed to the adult criminal justice system. Then the last and the most important principle is the principle of natural justice. Basic procedural standards of fairness shall be adhered to, including the right to fair hearing, rule against bias, and the right to review by all persons or bodies acting in a judicial capacity under this Act. Principles of natural justice like right to a lawyer of one's choice, right to be heard, right to cross examination, right to see the records, prohibition against being a judge in their own case, right to appeal, etc., are some of the principles of natural justice which should be protected by the institutions vested with the power and responsibility under the Act. It may be noted that the principles flow from Article 21 of the Indian Constitution, and no person, whether a child or an adult, can be deprived of this right. A closer study of these principles disclose that the purpose of JJ system is to rehabilitate the child rather than punish the child under the adult criminal justice system. However, we see that we have deviated from the intent, from the purpose, from the principles of the juvenile justice system by incorporating a provision which allows the adult trial of child. In support of the argument that why children should be treated differently, we need to see the studies of different thinkers and philosophers who argue that there is a reason, there is a need that children should be treated differently. The reason why treating a child as an adult is taken with a moment of awe is that we have a duty of care towards them as part of our general opinion. Those who argue that adult trying for adult crime should understand that trying children as adults demonize them like other criminals. Safety and security of children sent to adult prison is also a concern of those who believe in separate treatment of children based on diminished responsibility. However, this solely cannot be the reason to claim lesser penalty for children. The reason for treating children leniently is that they are more susceptible to rehabilitation and less habituated to criminal life. This is an interesting question worthy of discussion. The proposal is to treat children more leniently even though they may be equally culpable. The theory of justice, as it may seem to the public at large, should not only aim at giving wrongdoers what they deserve, but also at rehabilitating them. Though it may be worrisome that we do not know how to rehabilitate children. Giving a typewriter or some money may not be enough, as happened recently in a case in Uttar Pradesh. Several writers also believe that adolescents behave under pressure and they are less blameworthy because it is not in their control to resist. Children's deviant behavior may be regarded as generally less culpable than similar adult behavior for the reason that child's capacity to be culpable is less. A child's capacity to distinguish right from wrong and to control impulses is not as fixed as absolute as an adult, and thus they deserve less punishment because they have less capacity to control their conduct. Jeffrey Blueston argues that children are guided by impulse and they find it difficult to resist. He says that children are less blameworthy basing on a starving man analogy. Desire for food of a starving man may be so overwhelming to him that he may steal to eat where he has no money to buy food. The desire for food is normally resistible, but for a starving man it becomes irresistible. Analogously, children cannot resist committing an offense because they are children. The tender age of a person weakens his defenses to resist. However, Norman Richards argues this same thing basing on a different analogy. He says to be held responsible for criminal actions, a person should be able to resist, but he does it knowing the consequence of the criminal actions that it will harm the offenders. However, in case of children, a child should resist but they cannot. They do something perfectly freely To do something perfectly freely is more blameworthy than acting under the pressure of not being able to resist. Adults, on other hand, outgrow such pressures and do out of volition unless the case comes under any of the defenses prescribed under the law. We also need to understand the problems of fixing a minimum age of criminal responsibility. Fixing any age limit for reducing criminal responsibility becomes problematic when a child has no birth certificate or any other proof of age as required under Section 94 of the JJ Act 2015. It is common for children not to have their birth certificates, especially in a country like India. In 2003, UNICEF reported that 36% of unregistered births across the world. The JJ system faces more problems when the children are missing any formal proof of age as required by the statute. Section 94 of the JJ Act prescribes that birth certificate from the school matriculation or equivalent certificate from the concerned examination board should be produced, or birth certificate from corporation, municipal authority or panchayat shall be produced. In absence of any of these above documents, ossification test needs to be conducted. Now, it is quite possible in India that children may not have the formal proof as prescribed under Section 94. We all see that lot of floods come across India, in different parts of India. We see that the migrant children, those who do not have any permanent place of residence, it becomes difficult for those children to go to school and to procure a formal proof of their from a proof of their birth certificate. In such situation, if we allow the adult trial of children and transfer the children to the criminal court, to the children's court for the trial, it becomes very painful, very problematic, and may lead to injustice, and also may lead to the frustration of the purpose of the juvenile justice system. That is all for the lecture. Thank you.